Hello, and thank you for joining us for another panel as part of our conference. This panel is going to focus on the Child Parent Security Act, which passed in April 2020 and will become effective in February 2021. And we have two of New York's leading adoption attorneys joining us today to take us through some of the highlights of that legislation and how it will change the law in New York. And I'm thrilled and delighted that they have agreed to share some time with us this morning and do these, share their expertise about these issues with our viewers. Brian Esser is an adoption attorney in Brooklyn. Casey DiPaola is a law school classmate and an adoption attorney in Albany. And they're wonderful attorneys, and I know they're going to do a wonderful job explaining this new bill for us. So I'm going to start by turning it over to Brian Esser.
Thank you, Matt. I appreciate the introduction. I don't know if it's necessarily deserved, but I appreciate it nonetheless. Again, my name is Brian Esser. I have a solo practice based in Brooklyn, New York, and I focus on adoption and assisted reproductive technology. Today I'd like to, I'm going to talk about the donor conception provisions of the Child Parent Security Act. So we have a few slides here just to kind of, walk us through a little bit. Here's a little bit more biographical information about myself. When we're talking about assisted reproduction generally, there's kind of two facets to it. First of all, you need a doctor, and the doctor helps, well, maybe not necessarily a doctor, we'll talk a little bit more about that. But a doctor helps families achieve a pregnancy, and then a lawyer, and by extension courts, are required to make sure that only the people who are intended to be parents are considered parents to the child, and that no one else who was not intended to be a parent has a parental interest. And so as we're sort of thinking about, the law of parentage and how it relates to, to LGBTQ families, or, any family really that conceives a child with the assistance of a donor or a surrogate, these are sort of the guiding principles that we're thinking about. The Child Parent Security Act really has, basically revolutionized how, how we deal with assisted reproduction in New York. And I just kind of want to click through quickly, some of these things. Prior to the passage of the CPSA, we really only had one statute that dealt with sperm donation. It dated to 1973, and so it predated IVF technology. There were, a few bits of case law here and there that supplemented it, but that was our legal regime. The CPSA is a comprehensive statute that really, addresses all facets of assisted reproduction. Then again, as we sort of drill down and look at specific aspects, getting to sperm donation, the old law really only addressed married couples, and the technical requirements of the statute did require the assistance of a physician. The Child Parent Security Act expands that to, to recognize, married or unmarried couples, as well as single people, and the requirement that a doctor assist the family is not found in the statute. So, at-home inseminations are covered. Similarly, egg donation, there was one second department case, and then that was the only, reference to egg donation in our law. Again, fully codified and regulated. Embryo donation, to the best of my knowledge, there was no reference at all to embryo donation in our cases or statutes, and similarly, fully addressed by the CPSA. Reciprocal IVF, which is, when one parent contributes to the egg and then the other parent gestates the child. Again, there was one there was a case out of the surrogates court in Manhattan where the surrogate observed that there was effectively no answer under New York law as to, who is the legal parent of a child, born under that type of arrangement, whether it was the gestational parent or the genetic parent. The CPSA, addresses that. When it came time to confirm parentage for a non-gestational parent, second parent adoption was the only manner that was available. But now we have the ability to obtain a judgment of parentage, and a non-bio parent would only be recognized at birth as a legal parent if the two parents were married, and now we have a voluntary parentage. So there's a lot that has changed. The CPSA, some basic principles. First things first, it does not apply to conception of a child born via sexual intercourse. This is an assisted reproduction statute, meaning that there needs to be assistance. It does not address parentage of children conceived, quote unquote, the old-fashioned way. The statute is explicit that a donor is not a parent to a child, and that a person who consents to assisted reproductive technology, whether or not that person is the gestational parent, is a parent to the child, and again, whether or not they are married to the gestational or the genetic parent. And then the question of compensation is going to come up, from time to time. The CPSA does permit sperm and egg donors to be compensated, so they can be compensated for things such as their medical risks that they face, the physical discomfort, inconvenience, and their time. As it relates to the arrangement. Embryo donors generally are not compensated. I think I'll get into that a little bit later. In terms of what is sort of typical compensation, an anonymous sperm donor would be typically compensated a few $100s per deposit. An anonymous egg donor is typically compensated between $5,000 and $20,000 per cycle. Most commonly known egg and sperm donors are often not compensated, and like I said, the CPSA specifically says the embryo donor is only allowed to receive reimbursement for storage fees and for legal fees. So kind of sperm donation is is sort of the probably the hottest topic in the CPSA. It's by far I would submit the most common form of donor conception, and because it doesn't necessarily require the assistance of a doctor. There can be more litigation and more conflicts that arise among the parties, and because it can be accomplished in a more sort of informal way, I think it's important to sort of focus on it and focus on some of the elements here. So first things first, like I said, the assistance of a physician is not required. A recipient in a sperm donor arrangement may be a single parent, partnered, or married. The single parent piece is really important to note, because New York law prior to this really left single parents by choice, single women very exposed if they were conceiving a child with the assistance of a sperm donor, a known sperm donor, necessarily an anonymous donor, but a known donor, because there was no mechanism under our law stands right now to terminate the donor's parental interest. So that single parent, most commonly a single woman, face the risk that at some point in time in the future, the donor might seek custody or visitation of the child that she conceived within the use of the parent. And similarly, donors were exposed in that they could be sued for child support at some point in time in the future. The key here is with all types of donation is determining donative intent. And so because if you are holding yourself out to be a donor, you need to prove that intent. A donation made to a cryobank or a fertility center is construed to be evidence of donor intent. Otherwise, it needs to be in writing. Or donative intent can also be established by clear and convincing evidence. It's important to note that the CPSA doesn't specifically require a signed written agreement. Certainly a written statement of donative intent would be considered a best practice. I would never counsel one of my clients to move forward without a written agreement. But it can be established by clear and convincing evidence. The agreement doesn't have to be signed necessarily, does not necessarily need to be notarized, but there are other options that the statute provides, including witnessing by two people or signing in the presence of a healthcare practitioner. Egg and embryo donor arrangements. Those generally speaking have to be, not generally speaking, they do need to be performed by a reproductive endocrinologist. In those instances, a fertility practice will provide evidence of donative intent. In terms of sources, where do donor eggs come from and donor embryos? It can be a variety. Known donors, most commonly relatives or friends. Many fertility clinics have their own matching programs in-house. There are separate matching agencies. So similar to like a surrogacy agency where, they have a set of people who are open to being egg donors, and then they match intended parents with those egg donors. And then there are also egg banks. So similar to a sperm bank, the egg bank finds a set of donors who are open to, just donating, and then their eggs can be donated anonymously from the bank to an intended parent. Most commonly, known donors and donors for matching programs would enter into a written agreement directly with the intended parents. Commonly, clinics and clinic matching programs and egg banks would have no direct contract between the donor and the intended parents. I did want to talk a little bit about like a cooperative pregnancy or co-maternity, reciprocal IVF. These are all terms for the same arrangement, which is where one parent contributes the egg that is used to conceive the child, and the other parent gestates the pregnancy. So the egg would be retrieved from one parent, fertilized via an IVF process with sperm either from an anonymous donor or a known donor, and then the embryo would be transferred to the uterus of the gestating parent. I'm trying to be, gender expansive here and not, refer to, a gestational mother and a genetic mother, but, for if, that's kind of, where we're going with this. Like I said, so in the matter of Sebastian, which was a second parent adoption in New York County in 2009, the court observed that, that effectively, New York law recognized both women, in this case it was two cisgender women, as having possible parental relationship, but New York law at the time didn't specifically address which of the two women was was the child's legal mother. The court assumed for the purpose of the second parent adoption that the gestational was the legal parent of the child. And the Child Parent Security Act changes that, would recognize both parents as as legal parents of the child from the time of the child's birth. The sort of the $64,000 question in the context of non-biological parents or non-genetic parents is, how do we establish legal parentage and confirm legal parentage of a non-genetic or non-gestational parent in a donor arrangement? And so, we have now sort of, effectively 5 tools at our disposal under New York law to either establish that parentage or confirm that parentage if the child is recognized as a child of both parents at birth. So let's start with just the statute, which is always a good place to start. Under New York law as it stands right now, which is will be repealed effective February 15th of next year. The child would only be recognized as a legal parent to the non-gestational parent if like I said before, if the insemination was performed by a doctor, the consent was notarized, and the 2 people were married. The law expands that after February 15th to make clear that a donor is not a parent, and that a non-biological parent who consents is a legal parent of the child. Then we can layer on top of that a marital presumption if the 2 parents are married. This is just a sampling of the case law. To be perfectly honest, I think this is a pretty settled point at this time, that if we have a married same-sex couple, or frankly different sex couple as well, that the spouse is a legal parent of the child, even if all of the requirements of the donor statute, the old donor statute, haven't been met. There's sort of one exception to that, although it's forgive me. So the marital presumption will still remain in place even after the passage of the Child Parent Security Act. A new thing that the statute provides for is a voluntary acknowledgement of parentage. And so with this acknowledgement of parentage, similar to, we've effectively made the acknowledgement of paternity gender neutral and removed the genetic requirements. So the second parent is no longer saying that, by signing the birth certificate that he believes that he is the genetic father of the child. Instead, the person is attesting that that they intended to be a parent of a child born to their partner via assisted reproductive technology. And so specifically the statute says that it can be signed by a married or unmarried person who gave birth to the child and another person who is an intended parent under Section 581(303) of the Family Court Act of a child conceived through assisted reproduction. These voluntary acknowledgements of parentage are intended to have full faith and to be entitled to full faith and credit. It is supposed to have the effect of an order of parentage or order of filiation issued by a court of competent jurisdiction. It remains to be seen as to whether hostile jurisdictions. I often pick on Alabama, but like if you have if a family finds themselves litigating their parentage in Alabama, the question is, will Alabama actually give full faith and credit to a voluntary acknowledgement of parentage, and that does remain unclear. We have yet to, the statute hasn't taken effect yet. There's similar statutes in place in a handful of other states. To my knowledge, that hasn't been litigated yet, and remains to be seen. So it is still the recommendation that a best practice is that we advise our families to obtain a court order confirming the parentage of the non-biological parent. 25 years ago, the Court of Appeals in matter of Jacob, which is a landmark case, one of the first in the country, permitted the partner of a biological parent, an unmarried partner, to adopt the child and to establish, in this case, her legal parentage of the child. That was confirmed last year with a very short bill that said that even if the second parent is legally married to the gestational parent and already recognized as a legal parent of the child, that relationship can be confirmed via a second parent adoption. The CPSA creates an alternative process, basically, to obtain a judgment parentage that can be brought by an intended parent or somebody acting on the child's behalf. It can be initiated prior to the child's birth and is to be filed in the county where the intended parents reside, or where the child was born if filed within 90 days and the parents are not New York residents. The requirements are relatively straightforward. A statement from the intended parent about residency, statement from the gestating parent that the gestating parent became pregnant as a result of assisted reproduction. There's a non-gestating parent, a statement from that parent that that he or she intends to be a parent under the statute, and proof of the donor's donated intent. The judgment of parentage was drafted specifically with the intent to be a less obtrusive means to obtain a court order. The judgment of parentage does not require many of the things that are required of a second parent adoption, such as a home study, criminal and child abuse clearances, medical certifications. Specifically, DNA testing is not required, and there's no explicit requirement that the court have a hearing. Second parent adoptions and presumably by extension judgments of parentage are entitled to full faith and credit. That was confirmed by the Supreme Court U.S. Supreme Court in 2016. And it is important for families to have the protection of a court order that is entitled to full faith and credit in the event that they find themselves litigating parentage in a hostile jurisdiction. That could take the form of a genetic parent or gestational parent trying to shut out the non-genetic parent, or if God forbid something happened to the genetic parent and the grandparent or aunt or uncle of the genetic parent tried to exclude the non-genetic parent. Judicial Hearing Officer Ross in Kings County wrote a really nice decision and order a few years ago, talking about the need to harmonize unsettled family law and definitions of legal parentage, and that in order to really give New York's legal mandate that both parents are recognized as legal parents of the child, that needed to be a mechanism to confirm that legal parentage. And then finally, the last means for a non-genetic parent to establish legal parentage would be through the doctrine of defective parentage. Again, this is a Court of Appeals ruling from 2016, matter of Brooke SB, which I'm sure many of you are familiar with already, and it established standing for a non-marital, non-biological, non-adoptive parent to seek standing to establish his or her parental rights. And so with that, I think that kind of concludes what I would like to cover here. And so I'd like to turn it over to Casey to talk about the surrogacy aspects in just a moment. Casey, I'm going to switch so that you can share your screen. Okay, there we go. All right, thank you.
All right, thank you, Brian. So let me just see if I can share here. Okay, there we go. So hello, everyone. My name is Casey DiPaola. I'm an attorney focusing my practice on adoption and assisted reproduction, and my office is located in Albany, New York. So as Brian said, I'm going to be discussing the surrogacy aspects of the Child Parent Security Act with you today. So this is just some background information on me. And then let's talk about surrogacy. So Brian touched on some of this, but just some quick background before we get into surrogacy, so we make sure that everyone understands the terms I'm using. So the CPSA talks about assisted reproduction in terms of egg, sperm, and embryo donation, and specifically excludes surrogacy from that definition and then deals with surrogacy separately. So then there's the term IVF, which is fertilization of an egg by sperm outside of the body, and then embryo transfer, which is the implantation of that embryo into the uterus. So gestational surrogacy is when a woman, who we refer to as the surrogate, carries a baby that she has no genetic connection to, meaning it's not her egg that was used to create the embryo. And she's going to carry that baby with the intent of someone else, who we refer to as the intended parents, being the parents of that child. Now, if the surrogate has a genetic connection to that child, meaning it was her egg that was used, then she would be called a genetic surrogate or a traditional surrogate. And I'll talk a little bit more about that later, but that's fairly rare these days. And so under gestational surrogacy, one, both, or neither of the intended parents may have a genetic connection to the child. So it could be one or both of the intended parents' egg or sperm, or they could be using donated egg, sperm, or embryos. So when you think about all the different people that might be involved in this surrogacy process, you potentially have an egg donor, a sperm donor, embryo donors, a surrogate, and one or more intended parents, and potentially the surrogate spouse as well. So quite a few people go into this process. Okay, so pre-CPSA surrogacy law. So this is what's still in effect now until February 15th of next year. So right now, our law's parentage is linked to biology and not intent. Compensated surrogacy in the state of New York is illegal, and there are actual criminal penalties for it. Uncompensated surrogacy in New York is not illegal. That's something I think that people misunderstand sometimes. Right now, it's not illegal, but the contract or the agreement that's entered into by an uncompensated surrogate and the intended parents is unenforceable. So you don't have the ability to go to court and have someone enforce it. That being said, there are still routes to parentage under the current law. So if the intended parents are the genetic parents of the child, meaning that it was their egg and sperm, they can go through a maternity and paternity proceeding to be declared the parents and listed on the birth certificate, but an adoption is required for non-genetic parents. So that is our current law pre-CPSA. And this is just the structure of how the CPSA is set up. And then basics, surrogacy basics under the CPSA. So the CPSA is going to allow intended parents, regardless of whether one, both, or neither are genetic parents, to enter into a legal and enforceable contract to compensate a surrogate to carry their baby, and thereafter to obtain a pre-birth order of parentage or a post-birth order of parentage too, but I think in almost all cases, people will opt for the pre-birth order of parentage. And just because I will inevitably refer to the shorthand version of that, we call it a PBO, a pre-birth order. So if you hear me say that, that's what I mean. So New York intended parents can use a surrogate in or outside of New York. New York intended parents can use a fertility clinic in or outside of New York. But right now, the way the statute is drafted, New York surrogates can only work with intended parents in New York. That's because there is a kind of some language that's inconsistent within the statute about the requirement of intended parents' residency. There is a cleanup bill that's being considered by the legislature and hopefully will be passed before the effective date of the CPSA that will make it so that only either the surrogate or the intended parents need to be a resident of New York. But as it stands now, if the intended parents do need to be New York residents to follow New York law. And so you would think then that the surrogate could work with intended parents outside of New York and follow that state's laws, but currently the New York Department of Health is taking the position that you would then need to look at what was done in that other state to make sure that it complied with the CPSA in order to issue a birth certificate to the child born to the surrogate here in New York. So they may change their mind on that, but it's just a little unclear right now. So the safe route right now is for New York surrogates to only be working with New York IPs for right now. All right. Okay, so the status of traditional and genetic surrogacy under the CPSA. So the contracts, it's largely the same. The contracts are still unenforceable, even if she's uncompensated. If it's compensated, it's still illegal. And basically, we're treating these as adoption cases. So the only compensation that's allowable is what a birth mother would receive in an adoption scenario. And the genetic surrogate can change her mind. So you're not entitled to a pre-birth order, and you would have to follow the adoption procedures thereafter, which requires her to consent. Okay, so this is the surrogacy process, and some of this doesn't come from the statute, but just what practically happens in a surrogacy journey. And I think it's important to understand this to kind of put the pieces together. So the first step is typically that the intended parents need to create embryos. So sometimes they are creating embryos from their own gametes, and then sometimes they're obtaining donated sperm, egg, or embryos. Around that same time, they're typically selecting a surrogacy matching program. They certainly can do this independently, and I'll talk about that in a moment. But if they're going to work with a program, they would select the program at that point. The programs, generally what they're doing is they're advertising for surrogates and they are screening the surrogates. And when we're talking about screening the surrogates, it's going to differ by agency what they do to screen surrogates, but typically things like a drug screen, an STD screen, fingerprinting for criminal history, a child abuse clearance, sometimes obtaining credit reports, DMV abstracts, medical records, those types of things. So they're making sure that the surrogates are eligible under law, but also under agency policy and what the general requirements that the medical professionals are going to want to see in order to clear a surrogate. It is possible the Department of Health is going to be regulating surrogacy programs in New York. And so it is possible that the Department of Health will issue detailed regulations that are going to standardize surrogate screening. It's just still to be seen. We're hoping that those regulations come out before the effective date of the CPSA, but we're still not sure about that. Okay, so then the surrogacy program would match the surrogate and the intended parents, and then you'd be jumping into the clearance process, which is going to be medical clearances done by the fertility clinic selected by the intended parents, and then also a psychological evaluation done by a social worker, and that might be either a social worker associated with the surrogacy program or with the fertility clinic. There's also going to be an insurance review process where the surrogate's medical insurance is reviewed to determine whether it would cover a surrogacy pregnancy and whether it complies with the requirements of the CPSA. Then once that's done, you're moving on to the legal phase, which is the negotiation and the execution of a surrogacy agreement, during which both sides are represented by independent legal counsel. The next step is to be purchasing any insurance that's necessary. So that may be medical insurance or medical supplement, life insurance for the surrogate, and potentially disability insurance for the surrogate if she requests that. Also, around that time, the intended parents have to execute wills. So the purpose of that is that if they were to pass away before the child was born, they are still the parents of that child, and so a parentage proceeding would need to be brought on their behalf. Their executor also needs to carry out their responsibilities to their surrogate under their surrogacy agreement, and also they would be naming guardians for their child, because just because they were gone doesn't mean that the surrogate, you know, becomes the parent of this child or anything like that. So they can name their guardians there. The statute doesn't require a healthcare proxy or a living will for the surrogate, but that is something that is typically done in practice, so that there's something in place to make sure that if something happens to the surrogate while she's pregnant, there's somebody in place to be making medical decisions for her. And if she's comfortable doing so, her living will can specify that she would be kept alive until the baby could be delivered at an appropriate time. Once all of those steps are done, then there is a legal clearance letter issued to the fertility clinic. And that might come from one of the attorneys, typically the intended parent's attorney, or from the surrogacy matching program. But it's really important that all of those things listed above have happened before that legal clearance letter is issued, because that's what triggers the clinic to go ahead and schedule the embryo transfer and for the surrogate to start her medications in preparation for that. Then the embryo transfer occurs, hopefully results in a pregnancy. And then the next step is the parentage proceeding, which typically, I think that I will typically start them in the second trimester, just so that you have enough time to get them done before the baby's born, in case the baby comes early or are there any issues. The hospital would be made aware of the surrogacy arrangement, provided with a copy of the judgment of parentage in advance, especially when these are new, so that any questions can be addressed, you know, before everybody's there for the delivery and the filling out of the birth certificate forms. And then the intended parents should be listed as the parents on the original birth certificate if there's a pre-birth order of parentage. Now, I said I would talk about an independent surrogacy journey. So if you're pursuing an independent journey, meaning that there's no surrogacy program involved, then you're basically kind of like a private adoption. The intended parents are looking for the surrogate on their own. So they're finding a surrogate that they're matching with, sometimes via social media, via friends, family, you know, those types of things. And then depending on whether, you know, if it's the sister of the intended mother, maybe they're not going to do any kind of screening other than the required medical and psychological, but they're not going to have her get fingerprinted. But if it's somebody that they just met through a Facebook group, the best practice would be for the intended parents to do some level of screening on this surrogate before they get started. And that's something that either their attorney can help them with, or some surrogacy agencies will offer those services without, you know, signing on with the agency for all of their services, might still be willing to screen a surrogate that intended parents bring to them. And then intended parents are really going to want to connect with legal counsel early on if they're pursuing an independent surrogacy journey. New York statute is very detailed, and the requirements have to be met in order to be able to obtain that pre-birth order of parentage in a streamlined fashion. So it really is important that everything, you know, all the I's are dotted and the T's crossed. So early involvement of an attorney familiar with these laws is going to be really important, especially for an independent journey. Okay, so for surrogate eligibility, there are really, there's statutory requirements, so things that are in the law that are absolutely required, and then there are also guidelines that are put out by ASRM that are more like medical guidelines. So the court's not going to be checking in on those requirements, but you know, when you're thinking about whether your surrogate is an appropriate candidate, you want to be looking at those as well. So the statute requires that she be at least 21 years old, a U.S. citizen or a legal permanent resident, a New York resident for at least 6 months, unless the IPs have had that 6-month residency requirement. That she didn't provide the egg, so she's not a traditional surrogate, that she's completed a medical evaluation, that she's given informed consent to all of the procedures, that she's represented by independent counsel licensed in New York. And that's important because we see in this area of law, probably more than any other that I'm familiar with, that attorneys work in other states that they're not licensed in, and New York is not going to permit that. That's not to say that you can't have, you know, if another law, if a surrogate lives in another state, that she can't have counsel also in that state, but she needs to have a counsel licensed in New York as well. She has to have comprehensive medical insurance that's going to last for 12 months after the pregnancy ends, and ends via delivery of a baby or miscarriage or a termination of the pregnancy. She has to have a life insurance policy in place, and that life insurance policy needs to be $750,000 or the greatest amount that the surrogate can qualify for, because your eligibility for life insurance is actually based on income. So sometimes a surrogate who is a stay-at-home mom, for example, might not be able to qualify for that full $750,000. And then any other requirements that the Department of Health might issue in their regulations. And then in terms of marital status, a surrogate can be single. She can be married if her spouse is participating, or she can be married but physically separated for 3 years, or living separate and apart from a separation agreement. And if it's a separation agreement, it could be signed, you know, the day before and she's eligible. But if there's no separation agreement and it's just that they're physically apart, it needs to be 3 years before she could be eligible to be a surrogate. Okay, so, and I mentioned ASRM, that's the American Society for Reproductive Medicine that puts out these guidelines. So you saw that the medical clearance on the last slide is a legal requirement. The psychological clearance is not a legal requirement. It's not in the statute, but it is required. It is suggested by ASRM and really is the industry standard. And so that's here. They also put an age on the high end. So we're talking 21 to 45. At least one prior uncomplicated pregnancy, no more than 5 previous deliveries and 3 via C-section, that she has a stable and supportive family environment, and then a medical evaluation, informed consent, and no financial or emotional coercion. And the financial or emotional coercion and the stable and supportive family environment, those are going to be things that are explored during the psychological sessions. But you really want to make sure that there isn't a situation where a spouse is maybe twisting their arm to do it for financial purposes, or that they're in some type of domestic violence situation and are being pressured into it against their will. So those are important aspects of the psychological clearance, as well as making sure that there are no personality disorders, that they've really thought through some of the trickier issues with surrogacy, such as abortion or selective reduction, where you're reducing multiple fetuses. So, and also just talking about communication styles, making sure that the intended parents and the surrogate are on the same page on all of those important issues. Okay, intended parent eligibility, same thing, statutory requirements and then medical guidelines. So the statutory requirements, there's far fewer, as you can see, for intended parents. So at least one of them is a US citizen or lawful permanent resident. That does mean that for the most part, what we think of as international surrogacy can't happen in New York. So you can't have, for example, a Chinese couple who are not US citizens or LPRs coming in and using a New York surrogate. And as it stands now, as I said earlier, at least one of them has to have been a New York resident for at least 6 months. They also have to be represented by independent counsel licensed in New York, and the same requirements in terms of marital status, single, they can be unmarried intimate partners doing this together, a married couple together, or if they're married but separated, those same rules as for the surrogate, 3 years living apart or pursuant to a separation agreement. Okay, and then the medical guidelines, so that there's a true medical condition that precludes them from carrying a pregnancy or would cause significant risk to the person carrying. And so, that includes a woman who has those medical issues, but it also includes a single male who can't carry on their own, or a same-sex male couple. The psychological clearance is recommended for the intended parents as well. And then if they're the going to be the genetic parents, meaning that it's their egg and or sperm, that they're going to go through screening and testing. similar to what an gamete donor would do. Let me just go back. So again, these aren't requirements that the court is going to look at unless the Department of Health issues regulations on these issues, but just something to be aware of that are best practices. And okay, so the surrogacy agreement, there are very specific things that are in the statute that need to go into a surrogacy agreement in order for it to be enforceable and to lay the groundwork for a pre-birth order. And so it needs to be signed and verified or witnessed by two people. You know, I find, I also practice in Vermont and New Jersey, and in Vermont, we always just have the two witnesses, but I'm already hearing from judges in my conversations with them that they would really prefer that these agreements be notarized. So, and there is discussion with the judges as well about whether they're going to require court appearances when you apply for the pre-birth order. And I'm hearing that the more that you dot your I's and cross your T's and go the extra mile, the more likely they are to consider not having a court appearance. So one of those things that was mentioned was making sure that the agreement is notarized. So for what it's worth. Also, it needs to be signed before the surrogate starts her medications associated with the embryo transfer. It needs to specify that her base compensation and reasonably anticipated additional expenses will be deposited with an independent escrow agent before she starts her medications. So an independent escrow agent means that it's not either of the attorneys for the parties, but it can be the surrogacy matching program as long as the surrogacy matching program is run by a licensed attorney. The agreement also has to disclose how medical costs are going to be covered and a review of the surrogate's medical insurance. And so the way that that's probably going to be done is that when her insurance is reviewed earlier on in the process, you get an opinion letter back from the company that does that. And that will probably just be, I would imagine, an exhibit to the agreement. Also, the names and contact information for the intended parent, surrogate, and her spouse, if any, attorneys for both parties, and any known gamete or embryo donors and the surrogacy program are all going to go into the agreement. And so that's something interesting to note, is that known donors are actually going to be listed right in the surrogacy agreement. Okay, the surrogate is also agreeing to undergo embryo transfer. She's agreeing to surrender custody of the child at birth. She's acknowledging receipt of the surrogate's Bill of Rights, which I'll talk a little bit more about later. The agreement has to specify that the surrogate gets to make all of her own health and welfare decisions, and that includes everything from whether to have a C-section, whether to have a single or a double embryo transfer, and whether to terminate or continue the pregnancy or selectively reduce. It has to specify that the surrogate has a right to counseling throughout the process, and also a notice to her that her compensation may affect her eligibility for public benefits. So if she is on SNAP or other types of assistance, it's just warning her that this type of income could affect that eligibility, so that she's aware of that. But it isn't, being on public assistance is not a bar to being a surrogate under New York law, although it's typically been best practice not to have surrogates be on public assistance. New York took a different direction in that. The surrogate does have a right to disability insurance if she requests that, but for practical purposes, that's difficult because once the process has started, she's typically going to be ineligible for a disability policy that doesn't have an exception for this surrogate pregnancy. So that's one of the issues, again, being dealt with in this cleanup bill. And that the agreement also has to say that the IPs, the intended parents' rights, are not assignable. So they can't say like, never mind, we don't want this kid, we're going to assign this contract to our friends and they'll be the intended parents. You can't do that. And then it also requires the intended parents to execute their wills before embryo transfer. And so just to recap, so when we say that, so the intended parents are taking custody of this child, regardless of the mental or physical condition of the baby, regardless of how many. So if there are twins or triplets, they are the parents of all of those children. And they are the parents of this child, even if the surrogate does something like drinking or using drugs during the pregnancy that results in some type of disability for this child. You know, there might be a lawsuit against the surrogate for those actions afterwards, but it doesn't change the parentage. And one other thing to think about is in terms of the surrogate having all of the rights to make health and welfare decisions, she has the right to terminate the pregnancy at any time, and you know, provided she's allowed to otherwise under law, but she has that right. And basically the CPSA says that any attempt to limit that right is void and unenforceable. So surrogacy agreements will typically say, will provide penalties. So they'll say that, you know, she has the right to terminate the pregnancy, but if she does, you know, she'll reimburse the intended parents for their expenses. It's going to be interesting to see how the courts handle that in New York. I mean, the provision would be void and unenforceable, but is just putting it in the agreement going to be a problem? Would it make the contract non-conforming and cause a problem when you go to obtain the pre-birth order? That's kind of all still to be seen as we work through this statute once it's actually in practice. Skipping ahead here. Sorry about that. Okay, so then there are additional provisions that are typically, sorry about that. Okay, so there are other provisions that are typically in surrogacy agreements that are not required by statute, but that are very important parts of the agreement. So there's often going to be restrictions on the surrogate's conduct, and that might be a very broad provision that basically just says that she shouldn't do anything incompatible with a healthy pregnancy. Or, you know, I've seen contracts where there's pages full of restrictions on what she's going to do, such as not scooping cat litter, not eating deli meat, no unpasteurized cheese, no saunas, hot tubs, those types of things. There's often restrictions on her travel at the end of pregnancy. And the reason being that, you know, everything's set up to be handled, assuming that a birth is going to happen in a particular state. And if she's in a different state and gives birth, that could cause a lot of problems from a legal perspective. And also, you know, the intended parents might have selected a surrogate who's close to them so that in the event of, you know, the baby being born early and needing NICU care, they're close to home and not, you know, 4 states over trying to manage that. There's usually also an agreement on who her doctor is going to be and where she's going to deliver, although I think under the New York law, she could change that, and there's not a whole lot the intended parents could do about that. There's also specifics usually on who's going to be present for the delivery. And, you know, obviously those are going to be subject in the near future to hospital restrictions based on the pandemic as well. They'll also specify the number of embryo transfers that she's willing to undergo, and also the number of embryos per transfer. So will it be a single embryo transfer each time, or is she open to a higher number if the doctor recommends it? You know, either because they're intentionally trying for twins, or because, you know, the embryos are determined to be of a lower quality and less likely to result in pregnancy. There's also going to be provisions about confidentiality, what constitutes a breach of the agreement, and what the remedies are. And then there's also going to be a substantial section on compensation, assuming it's a compensated case. So typically there is base compensation, and, you know, I see anywhere from $25,000 to about $45,000 for base compensation, I think is reasonable. And then there's additional compensation for medical procedures and events that she's undergone or experienced. So things like if she undergoes amniocentesis, or she has to have additional embryo transfers before she gets pregnant, or if she miscarries, or the intended parents ask her to terminate the pregnancy due to a diagnosis of the baby. She's also typically going to be, one other thing, loss of reproductive organs. There's usually compensation set up for that as well. And then also for maternity clothes, for travel expenses, her uncovered medical expenses are going to be covered. Lost wages are typically covered if she's going to be out of work, either to go to screening appointments or embryo transfers, medical appointments, and then her delivery and post-delivery recovery. Childcare expenses for those same periods of time, typically only if she's not already going to be using childcare. sometimes compensation if she's going to pump breast milk that she's going to ship to the intended parents. And then sometimes also housekeeping and meal preparation if she's either on bed rest or physical limits or during the recovery period after delivery. And then back to base compensation, just briefly, typically a surrogate who has already carried before, so she would be called an experienced surrogate or an experienced carrier, they typically receive higher compensation because they've gone through it previously. The concept being that they've gone all the way through the process successfully. They fully understand the concept of surrogacy. Their body responded well to the embryo transfer, kind of all of those things rolled into one. All right. And then I mentioned before the Surrogate's Bill of Rights, and that is has to be given to the surrogate before she signs her surrogacy agreement. And ideally, probably as soon as the surrogacy program starts working with her, it should be one of their first communications with her. Same thing with an attorney working with a surrogate, because it tells her what her rights are under New York law. And this applies to surrogates residing in New York, regardless of whether they're following another state's laws. And so it tells her that she gets to make her health and welfare decisions. She has a right to independent legal counsel. She has a right to have her insurance and medical costs covered. She has a right to having counseling and have that covered, a right to life insurance, and a right to terminate the surrogacy agreement before she becomes pregnant without owing the intended parents anything for any of the costs that they've paid for. And so ideally, I think this should actually be like a PDF, that can be emailed and, a document that can be given out, basically copying and pasting the statute to make sure that it's complied with. Okay, and then the parentage proceeding. So similar to the parentage proceeding for assisted reproduction that Brian was speaking of, you can file this in Supreme Court, Family Court, or Surrogates Court, and probably which court your attorney suggests is going to depend on the county that you're in, because they just, have different personalities in each county. So you can file anytime after the surrogate becomes pregnant, but typically the second trimester, as I said before. There may be a court appearance, but I think that the courts will be understanding of allowing people to appear electronically, especially with the pandemic. Now that all of our court appearances have been electronic, I think the courts are becoming much more comfortable with that. So hopefully that will stay the same, because oftentimes the surrogate and intended parents live on opposite sides of the state or the country from each other. So in person becomes difficult. And then the judgment of parentage itself is going to specifically state that the intended parents are the legal parents from birth, that the surrogate and her spouse, if she has one, are not the parents of the child, that the donors, if any, are not the parents, and direct that the intended parents be listed on that original birth certificate. Or if this is being done post-birth, it will be an amendment of the birth certificate to list the intended parents. Now, these proceedings are going to be sealed, but the parties and the child can have access. So that means that the child will be able to find out the identity of the surrogate as well as any known donors. So that's just something to be aware of, that not everything will be anonymous. And so surrogacy programs in New York, I've talked a little bit about them along the way, but what they do basically is they're recruiting and screening surrogates. They're matching surrogates and intended parents who are like-minded on the major issues surrounding surrogacy. They're also providing referrals for escrow agents to manage the funds during a surrogacy journey, for attorneys who are experienced in assisted reproduction and surrogacy, for gamete and embryo donation programs, and for fertility clinics if needed. And then they're overseeing the process from start to finish. Well, if you're working with a full service agency, which I think New York agencies are going to need to be, because the statute requires that they're kind of keeping track of statutory eligibility requirements. So they're overseeing the process, and they're providing support to all of the parties along the way and making sure things run as smoothly as possible. And then the kind of quirks for New York surrogacy programs, I believe that we are, and Brian, you can jump in and tell me if I'm wrong about this, but I think that we are the only state in the country that regulates and licenses surrogacy programs, and we're...
Yeah, I think that's right. You're right, Casey. We're a leader in that area.
Yeah, I thought so. So we are the only state that's going to regulate and license surrogacy programs. That's going to be the Department of Health that's doing that, and we're still waiting to see what that's going to look like. There are ABA, the American Bar Association, model regulations for surrogacy agencies. And it's possible that they'll follow that mold, or maybe they will follow the adoption agency licensing model, still to be seen, but hopefully we'll find out soon. But if you are thinking about working with a surrogacy program, before those regulations come out, it does say that surrogacy agencies have to be licensed once the regulations are promulgated. So it doesn't mean that you can't work with an agency until those come out. If a surrogacy agency is owned by an attorney or a law firm, that attorney or any other attorney in their firm can't represent any of the parties. So the agency really is supposed to be a separate independent entity. And there can't be any referral fees going back and forth between attorneys and fertility clinics and surrogacy agencies. And a fertility clinic can't operate its own surrogacy agency. And so basically the surrogacy agency is going to monitor compliance with the surrogacy agreement and the eligibility requirements in the statute, and also is responsible for providing information for a voluntary central tracking registry regarding the surrogate and the medical outcomes, but completely voluntary. So if the surrogate chooses not to have her information put into that registry, that doesn't have to be done. But it's interesting that that falls on the programs and not the fertility clinics. Okay, and I think that that is all I have. So let me turn this back over to Matt. Just one second.
Thank you so much, Casey and Brian, for that really awesome overview of all the legal details and changes that are coming to New York in February. I really appreciate your time and expertise this morning. One thing I also wanted to do with this particular panel was to try to make it real and try to bring home, the real personal impact of the Child Parent Security Act. And to do that, I've invited Dennis Williams, who is the Senior Vice President for Corporate Social Responsibility and Corporate Affairs at HBO. But today he's here in his capacity as a dad. And I'm really excited to talk with him and just learn a little bit more about his journey to fatherhood and to try to help people better understand what the CPSA will do for New York families. So first of all, Dennis, can you share a little about your journey to fatherhood?
Yeah, sure. I was, as you were saying, my professional title, I was thinking I'm probably a little better at that than I am at parenting most days. But the snack drawer is pretty full. So yeah, absolutely. My son was born in May of 2016, and I probably started the process of really actively thinking about being a parent maybe about 8 years or so before he was born. I was sort of approaching a stage in my life, my late 30s, where I was starting to wonder whether or not there was going to be a Prince Charming, who kind of would ride into the sunset in my fairy tale. And that wasn't looking like it was likely to happen at that point in my life. So, I explored this conversation back when I was in a relationship with someone and had gotten pretty far, down the path. And then around 2010 or so, a friend a friend introduced me to someone who offered to be my egg donor. And so, that was such a generous offer. I did that and kind of, created embryo, had those embryo frozen. And then a couple of years later, when I thought my life was in a pretty good place and had kind of figured out that I could probably navigate parenthood as a single parent, I started looking for a gestational surrogate, and then kind of went on from there.
How did you ultimately come to decide on the surrogacy route to create your family?
It wasn't the first choice for me. When I was in a relationship, my ex-partner and I had talked about all the different options. And each one, has its own sort of considerations. So, I wasn't raised by someone who is biologically connected to me. My dad, who raised me, though, is one of the most important people in my life. So I sort of understood from my own experience that there wasn't a necessity for me to have a biological connection to someone for me to love them, right? And so I thought about, sort of adoption or foster care. But once I wasn't in that relationship and there sort of weren't two of us deciding that, I just didn't have a whole lot of confidence that as a single Black gay man, those options were going to be as, successful for me as sort of creating it on my own, right? I kept thinking, I was looking at friends, for example, who were creating adoption books and sort of, presenting themselves to potential parents looking to place their child with adoption. And I thought, well, who gives the single Black dude in Brooklyn, the kid over all of these other potential parents or intended parents? And so I just kind of thought, the surer way for me to become a parent, the quickest way might be for me to explore surrogacy on my own.
And once you made that decision, what burdens did the old state of the law in New York sort of place on you?
Many, actually. I mean, it's really fascinating because I've lived in New York now for a couple decades, and I think about how often I tap into my resource of people, my network of people around me for any number of things, right? Like, what school do I want my kid to go to? Well, I talk to parents who've sent their kids to schools in my neighborhood. What teacher in the building do I want my kid to be, whose class I want my kid to be in? I talk to parents who are at the school. And that's how we make really important decisions in our lives. We go to our network. So I know a lot of doctors, I know a lot of lawyers here in the state of New York, but I couldn't count on any of those people to provide resources for me once I realized I had to do this process outside the state of New York, right? So in my particular situation, my gestational surrogate, who is a great friend of ours and a family, now, she was in the state of Kansas. My friend who donated eggs was in the DC, Maryland area. I was in New York. And so we were really sort of triangulating. When I went to find a lawyer, for example, to represent the gestational surrogate, I didn't know who to ask in Kansas for that referral. I didn't know who to ask in New York that knew that knew lawyers in the state of Kansas. So, just sort of it overly complicates a process that's already difficult and full of challenges. It just adds additional layers of complication to it. How
has fatherhood changed your life?
I think, ask any parent, right? Your life my life is fuller. I mean, if I had the wherewithal, if I, didn't live in a smallish apartment in Brooklyn, if I had different resources, I would have, a house full of kids. I mean, I love it. I think it has been, one of the best decisions I've made. My son is he's the reason we get up in the morning in our household. We get up on his schedule, we buy cereal according to his demands. But it's great. My family was incredibly supportive. My circle of friends, incredibly supportive. And so it's just been a very, very great experience all around.
How did you come to be involved with efforts to update the law in New York?
When you're going through the process, and I mean, I sort of knew that surrogacy wasn't allowed, the kind of surrogacy that I wanted to do wasn't allowed in the state of New York. But until someone tells you personally no, right, when it impacts you directly, I think that's when you really get a sense of how unfair it was. And then I tend to think of myself as a pretty logical person. Not only was it that it seemed unfair, but it also didn't make sense to me. It was like, wait, you can do this in other places like Kansas or Ohio or Texas, but I can't do it in New York of all places. So I sort of made a little, mental note to myself that I would try to do something after I had more bandwidth and more time after my son was born. And so when I came back and started to think about all the other people who were asking me about my experience, particularly people of color, particularly my, cisgendered female friends, other single men. I thought there are a whole host of people who are interested in doing this, and that path shouldn't be as complicated for them as it was for me. So let me figure out what I can do to try to make this better for people who come along after me.
And what was it like to put your own family out there as part of the advocacy?
Oh, well, I mean, I hope somewhere there's a photograph of you know, me and my toddler in Albany, and that someday Alon looks back and he recognizes how incredibly fortunate and unique his narrative is, and that, you know, I mean, I made the decision for us to do that together because I think visibility matters. I think, you know, grounding this in real experiences, the experiences of real life New Yorkers was important. And as I said earlier, I also felt like so often the optics of surrogacy in particular, you know, what we see is like you know, this is a process that's for privileged, often white gay men who are in relationships, right? I mean, it's sort of this, you know, it's the new Colgate commercial, right? To kind of see those images. And I knew that we weren't that. And I knew a whole host of people, as I said, who didn't fit that. And so I just wanted us to be visible and be seen so that other people would be inspired to do the same.
And how did it feel to see the bill finally cross the finish line?
It was not a surprise. I mean, I felt all along that if New Yorkers who tend to be really pragmatic and smart, I think by and large, I felt like once people knew. So often when I was having conversations with people, I would say, well, you know, the reason I had to leave the state is because I'm not allowed to do it here. And they just had no idea that was the law. And so I was always optimistic that it would pass. And then I think when, you know, in the process, when we had some hurdles and some hiccups and some opposition, I was stunned by that, you know? And so maybe for a moment had some doubts, but once it finally crossed the finish line, I thought, okay, you know, we finally caught up to where we need to be. And now it's just a matter of continuing to make sure that this process is as accessible and as fair and as equitable as it possibly can be.
Well, thank you so much for what you did and for sharing your story today. I really appreciate it.
Absolutely. Thank you for letting me be a part of it.
All right. And thanks again to Brian and Casey. And I will hopefully see you all once again in person when things get back to normal. But myself, my commission, and all the viewers that will watch this really appreciate you all sharing your expertise and your stories.
Thank you so much. Bye, everyone.
Thank you. Bye.